Hello, everyone, and welcome to the webinar channel of the Association of Certified eDiscovery Specialists. My name is Mike Quadraro, and I am the president of ACEDS. We are joined today by our fabulous partner, BIA, for an Ask the Expert year-end Q&A webinar. We'll get to introductions in a minute. BIA, of course, is one of our longest-standing partners. Of course, we're grateful for their continued support. BIA is a trusted leader in eDiscovery and digital forensics for 2 decades, managing projects across the eDiscovery lifecycle. One of the cool things about BIA is that nearly all of their personnel and all of their project management team are ACEDS certified. I know it's a point of pride for them, and frankly, a great highlight of their commitment to professionalism and service to the eDiscovery community. You can learn more about BIA at biaprotect.com. All right. Before we get started, we love questions. In fact, this particular webinar is dependent upon questions. It's an Ask the Expert webinar. So please ask your questions using the webinar. I'm using the Q&A widget at the bottom of your screen. All right, so that we can get started, I will turn it over to Mark McDonald at BIA. Mark, please take it away.
Thank you very much, Michael, and thanks to everybody for attending our webinar today. As we close out the year, and we wanted to change things up a little bit here. So, the idea with today's webinar was that we wanted to engage the audience by asking questions to you, the audience, and, take turns at answering them with our table of experts. We have lots of great questions, and so we're going to get started really soon. We'll do a quick roundtable and some intros. As we move through the slides, Peter Bruce from ACEDS will be polling the audience so that you can rank the questions on that slide in the order that we'll answer them. So each slide we'll devote about 10 minutes to, and we'll try to answer at least the first 3 questions. For shorter questions, of course, if we can, we'll answer them all. Any questions we don't get to will become part of our BIA blog, and you'll all get an email when those are up. Let's get started with some quick intros and then dive into questions, but we hope you'll take away some knowledge and maybe a new perspective on how you handle your eDiscovery based on some of the information that we'll share today. So today we got Brian Schrader. Brian's a technologist and an attorney, having testified as expert in many high-profile cases since BIA's founding back in 2002. Adam Feinberg is our EVP of services. He leads our digital forensics operation, and all of our professional services teams report up to Adam. Barry Schwartz leads our advisory team, helps our clients with all aspects of the EDRM and best practices from legal hold straight through production. And Lisa Prouse is a relativity certified expert. She's our CVP of litigation technology and managed document review. And my name is Mark McDonald. I'm the SVP of Business Development here at BIA. As we approach the slides, we are going to give a 1-minute time frame so that you guys can begin to vote. I'm going to click through our slides here. Oh, thank you very much. It was magic. Our first set of questions is starting at the left-hand side of the EDRM around legal hold. And what we have are 5 questions. I'll read them to you, and then in that window, you'll be able to pick which question you want us to answer first. So question number 1. If we have Zoom meetings that we've recorded, how do I make sure they're being preserved for a pending litigation? Question number 2. Do I really need an automated legal hold software? We have 3 small matters per year, sometimes none. Should I be managing my legal holds, or should I have my outside counsel do it for me? Number 3. I'm new to a company with a lot of backup tapes, and I'm concerned that historically they've been used for sources of ESI for preservation purposes or litigation purposes. How can I stop, and there is a way I can claim them to be used for disaster recovery only? Number 4, how do I ensure a legal hold on my ESI for custodians who have on their personal computers and devices? And question number 5, with the surge of remote workers across the globe, what does this mean for legal holds and data preservation on international virtual cloud servers, and what about GDPR? So, Peter, I can show our ranking window. And look at that, already some quick first results. Did our minute expire? Are we ready, or do we want to refresh that one more time? Let's see. We've got looks like a dead tie for question 1, 3, and 5. How about that? Barry Schwartz, this is your territory, but other experts feel free to chime in. And let's just start with question number 1, Barry.
Okay, thank you, and welcome everyone. So, with respect to Zoom and other similar recording tools, let's take a step back. If your company regularly uses Zoom or Teams or one of the other video conferencing tools, you'll need to ask your groups if there's a business reason to record the call. And if there isn't a reason, then maybe perhaps you shouldn't make that recording. And some of the tools have the ability for admins to turn the ability to record off. And if you're faced with a triggering event that causes you to need to issue a legal hold and your recording of a call is in the corporate system, you can more likely than not do your preservation there. However, if the recording is on a privately owned computer or system that isn't controlled by your organization, then we recommend that you do the preservation virtually immediately so that you don't lose it along the way. And one way to determine whether or not you have any of these recordings is to ask your custodians through the use of the custodian questionnaire. And we find CQs to be invaluable across many, many areas of the legal hold world. And there is one other consideration that I want to put on the table that I don't think is asked often enough, and that is with the consent laws, and there's dual consent requirements in I think 11 jurisdictions in the U.S. To ask if it's okay to do that recording regardless of whether or not it has a valid business purpose. And so question 3 was the next one, Mark? That's a yes? Okay. So this question pertains to whether or not backup tapes are a burden, more or less. And with the most recent update to the federal rules, the burden question has more or less been addressed in those rules, requiring a balancing act between the parties. And frankly, we find the need to go back to tapes is less and less than it has been in the more recent past. But for this question, I'll pass it to Brian, who's had significant experience dealing with BIA clients on the issue of accessing these backup tapes. Brian?
Well, thank you, Barry. Yeah, Barry is right. The occurrence of this issue is very, very rare these days. The federal rules really changed the entire process, and you really have to make a showing that you're likely to get some pertinent information from those backup tapes. Before I kind of go into that, though, one of the things I like to say as a precursor, like Barry said, one of the best ways to avoid the Zoom meeting question is to tell your employees not to record Zoom or not to record meetings, or if they record them, make sure they got their notes. When they're done with them, delete them if they don't need them right away. And, so you avoid the question altogether. The same kind of thing goes with tapes. In most organizations, or I should say most, in many organizations today, backups are done differently. They're done in the cloud. They're done kind of more automatically. The concept of backup tapes just doesn't exist as much as it used to. And so one of the things that you should be thinking about is, to the extent your organization has backup tapes at all, is it time to get rid of them? Period. Is there any reason, business reason or regulatory reason, to keep those tapes around? Because, like with any, and this goes for any kind of data. I mean, you're hearing a lot of companies in the eDiscovery space talk about this today. We've been talking about it for years, which is strategic data retention or strategic data deletion, however you want to phrase it. The idea of keeping around the data that you need or that the regulations require you to keep around, but don't keep around anything else. And the same thing goes for tapes. For most companies, especially if you're in a company where you don't really use tapes anymore, you just have a bunch of these old tapes sitting on a shelf somewhere, you should make the strategic decision as to whether or not you ever even need those. And if you don't need those tapes, then get rid of them right away. And then you'll never face this question. But I do understand this particular issue because we had a client who at one point in time, their GC, who wasn't an eDiscovery person at all, didn't really have any eDiscovery knowledge, instructed their IT team, instead of putting everybody on legal hold, that they were going to just do daily full backups of their email. And they did it for a period of about 5 or 6 years in a company with thousands, if not tens of thousands of employees, of which at least 1,000 of them were on some legal hold or involved in a case. And that created a disaster scenario because one of the things courts will look at is the purpose of their backup tapes. And in that case, the purpose was clearly for litigation. And it was a really, really bad idea and exposed them to potentially tens of millions of dollars of restoration. They had like over 30,000 backup tapes at one point, and it was just a complete and utter nightmare. And we helped them get through that process, stop the bleeding, put a new process in place. And so it all comes down to the purpose. If you're just using those backup tapes still for disaster recovery purposes, then there is a strong public policy that prevents the courts from wanting or making you go back to those. The only time you're really going to have to go back to those tapes is if you don't put a legal hold in place timely and properly in the first place. If you put a legal hold in place when a case first comes out and you're preserving data, it's going to be very, very, very hard for someone to make a strong case to go back to backup tapes and force you to restore them. That said, even if you do, there are very good ways about doing selective testing that can help reduce those costs as well.
Thanks, Brian.
So, the last question on that list.
I think I'll make it brief so we can move on. With the surge of remote workers across the globe, what's the requirement for legal holds, and how does cloud storage and the GDPR fall into that realm? Well, legal holds can be issued to any custodian at any time in any location. And as far as cloud storage is concerned, one of the notions to keep in mind is that data is typically located in a geolocation close to where the user resides. That is, data in the U.S. for U.S.-based individuals is typically located in the U.S. And for the U.S., that's potentially, well, it's actually a near certainty. And likewise, in the EU, custodians' data is typically stored there. But remember, that's not always the case because a U.S. employee of an EU-based company may have their data stored in the EU and vice versa for EU-based people. And with the GDPR in particular, the data access follows the individual, not the company. And that's a tenet of the GDPR privacy rules. And with respect to accessing that data from a EU-covered individual, there are two ways to get that information involved into a litigation matter. One is direct consent of the custodian, and the other is showing a legitimate interest. And interestingly, it's been a long time. GDPR has been in play now for 2.5 years, just about almost 3 years. And the legitimate interest was just recently tested and reported on in a Dutch matter, where it was said that the legitimate interest is a valid reason for producing data without the custodian's consent. And so back to you, Mark.
Well, thank you, Barry. There's a follow-up to that question. If the custodian is overseas, but the data resides here on a server, does that implicate it? And you've got another 1.5 minutes left.
That's a tough question. And I don't know that it has actually been tested in the courts either here or there. If U.S. courts would have the tendency to say, if it's relevant to the case, admit it. However, with the EU rules, regulations, and the penalties associated with GDPR, if the data was introduced into U.S. courts without the legitimate interest or the custodian's permission, that could create a draconian fine for the company that produces that data. And so, as I said, I don't think it has been clearly tested yet.
Sorry for the curveball, but you took a great swing at it. Nice job.
We tried.
We've got 1 minute left on this slide, but I think for the interest of moving things along, let's move to our next one. And so this will be on data identification and collection. And Adam Feinberg, you are the go-to for this one, but again, any other expert, feel free to chime in. So Peter, if you'll start the countdown clock at a minute, I'll start reading our questions. Number 1, what should the IT department do when an employee is leaving the organization? As the in-house attorney, is it my job to guide them? If so, how do I do that? Number 2, when should we image computers as opposed to collecting live data? Number 3, have you ever had to collect anything from a smartwatch, Fitbit, Apple Watch, or others? How about from construction wearables? Is this common? Can we capture this from another place other than the device itself? Number 4, should my company image every computer and device for each and every exiting employee? Number 5, my vendor said they deduped, but why am I still seeing duplicates in the review database? And I might tap Lisa for that one as well. That was probably more than a minute. So Peter, we have some poll results. Whoa, look at that. I think we have a winner. All right, let's start with number 3, Adam.
All right, let's bring up that slide so I can see it, please.
Again,
oh boy, so
3.
yeah, Mark, I'll take, have you ever tried to collect from anything from a smartwatch for 100%, please?
Excellent.
So the soft answer is yes. If you have a smartwatch, you know, a Fitbit, an Apple Watch, an Android type watch, generally that data is synced to your phone or a computer. We've collected thousands of phones, so the answer is yes, we've collected that data. We can search that data that is collected, but oftentimes that data is not the authoritative, complete set of information that exists about the use of that specific device. Oftentimes the applications on the device are stored in other places, other cloud repositories. You know, I'm a runner, I'm wearing my running watch, my Garmin. If you were to try to collect the information from my watch, you would only find probably 30 days worth of runs on there because it's got limited memory, limited storage, and that data is synchronized up to my watch, my phone, to the Garmin cloud, also to Strava. So I would say that the other authoritative places would probably be the places to look for most, if not additional information. The second part of the question is an interesting one. The construction wearable market is a newer market. There aren't that many devices out there yet. There are a lot of companies that have some beta application of these things like smart hard hats, sensors that may go on people's work clothes or in their boots, or even things that go on construction equipment, you know, like backloaders and dump trucks and what have you. Pretty much most of those devices synchronize again back to a system in the back end that would probably be the most authoritative place to look for that data.
So, hey, Adam.
Anybody else want to jump in?
Yeah, I was just going to say, I was just going to add there, Adam. I think basically kind of what you're saying there is that one of the best ways to do this is to make sure that the device itself is synchronized, right? That the most recent data is up into whatever application or cloud app or, you know, smartphone app, what have you, and then collect from that more definitive, more, you know, long-lasting resource, as opposed to just collecting from the device itself, right? So best practice is to make sure your most recent activity is synchronized and then collect from the most definitive, most comprehensive source. Would that be a fair?
Correct. Yes, I would agree. And again, just you know, any kind of collection effort you want to do what's called data mapping, right? You want to speak to the custodian. You want to understand how they use a specific device. It doesn't matter whether it's a watch, a phone, a computer, or has access to any number of cloud resources. You want to work yourself through the use of various technology to understand how they use it and where they store the data and collect from the appropriate endpoint, I'll call it. Again, the one that has the most information possible.
Sounds good. And, there's a question that came in as we were asking this, I think really kind of goes hand in hand with this. The question is it appropriate to rely on the BYOD policy of the company, even when they assure you that they do not have any more ESI on other personal devices? I'll take the first stab at this. And it
Sure.
this actually kind of goes hand in hand with the first slide, legal holds, right? It's how do you deal with all this stuff? And this is much more important today because with everybody working remotely, or so many people working remotely, the use of personal devices has skyrocketed across the board. And so what we say is it's great to know that the company has that policy in place, but to use a phrase, I think it was Reagan who said, trust but verify. You can trust it, but the best way to handle that situation is to issue a custodian questionnaire. You can use SurveyMonkey if you want to do it. We don't really recommend using free services like that because they're not necessarily secure and private, or they may be secure but not necessarily private. Better to use some sort of a secure survey engine or custodian interviews. If it's a handful, you can just give them custodians a call and walk through. And one of the things you want to address is this, the company had this policy. Frankly, when we talk to companies about doing these things, we don't tell them to remind the employee that they might be violating a policy, right? Don't say, don't start out your questionnaire by saying, oh, the company forbids this, but let us know if you did it. Because you're going to get people who are going to be like, oh, I didn't violate company policy, right? Just ask the question. Did you use this? Did you use these devices? Did you use any of your personal devices to access information, whether that's your cell phone, your iPad, your watch, you can even access your email with some smart home devices as well. And so the best way to do that is, even if the company has the policy, still ask the questions, issue the custodian questionnaire. There's nothing better to really define the scope than a custodian questionnaire.
And I would add to that, bring your own device policies have their own issues. Number one, the end user is bringing their own personal device. All of their lives are on those personal devices. And then when time comes for litigation, the organization wants to dip into that personal device. That could be problematic. The person may not want to allow you to do it. Things may end up being more targeted than appropriate. Depending on the specific situation. And if your policy doesn't have some language in it that the end user has to comply with those requests, you're potentially looking for some trouble. I think we've all been involved just dealing with personal cell phones and how much trouble that has become in the collection space and the trepidation of employees handing over those devices that, again, contain all their lives, their personal pictures, their personal communications for litigation purposes. So, it's definitely problematic.
Yeah, Adam, let me interject here. This morning was on a client call and personal devices were in play. And we asked the question, do you have a policy that allows for the company to collect those personal devices? Said, no, we don't, but we need to have one. So a very timely point.
Right. And then the offshoot of that is what happens when the user leaves the organization and your ability to be able to remediate the computer of any corporate material. Right. Again, it is their personal device. You have no claim to their computer, but it may contain or continue to contain a treasure trove of your corporate secrets after that employee leaves. And if they leave, they can go right to a competitor, but you have no idea what's on their computer because they brought their own device.
or their phone or their watch or whatever. So, Mark, do we have time to answer any more of these questions, or do we need to move on to the next slide?
We have 1 minute and 6 seconds left on this slide. Maybe question 5 real quick for Lisa about deduplication.
Adam and I spoke about this yesterday. I'd like the forensic part first, if I may. Can I lifeline this or?
Yeah,
Sure.
you can totally do that.
Just like in the law, forensics words have specific connotations, right? And a duplicate is defined as 2 electronic files that are the same by hash, digital hash or digital fingerprint. A calculation is made on both of those files using one or many fields to determine its exact digital fingerprint or hash. All of those criteria have to be met between 2 files in order for them to be a duplicate, an exact duplicate. Certain things won't change hashes on a file, such as changing its name. That's not in the calculation. But again, what's inside the document is what matters. 2 documents on the face of them, if you printed them out and held them both up and laid them on top of each other and you looked at them, may look to be exactly duplicate. But within them, there may be an extra space or a hidden character that you may not see visually that no longer makes those documents be exact duplicates. Lisa?
And so where I usually see this is the documents have already gone through processing. They've been deduplicated. Deduplication is a process where it's identifying the duplicate files, and it's taking those files and it's suppressing them usually, but it's also taking the metadata from them and it's putting it into other fields so that you can still track the fact that the document that's sitting on the review tool has all the metadata that would have been attached to the ones that you've suppressed. That whole process is something that there really doesn't happen in the review tool. So when we once we've already deduplicated and removed the exact duplicates, the hash duplicates, we've got lots of tools that can help find what we call text duplicates. So 2 files that have the same information, the same words, but they don't have the same hash. And usually a good example of this is a Word document that you have printed to PDF. Chances are those are not going to have the same hash value, but clearly they have the same text. You just printed it to PDF, or an email that you've printed to PDF. So we've got lots of tools that can identify those, but we don't really deduplicate them at that point because we can't really just kind of mix and match all that metadata because they're not exact duplicates anymore. They are different files. So we can identify duplicates that didn't get deduplicated in processing, but we don't really deduplicate on the review side.
And just to confirm, we is not BIA, we is the industry in general, right? Yes. There are a lot of tools that can, just running searches, for key phrases, a lot of times will help you pull out some of the, very similar documents, but there are lots of documents where they will take all the words in the document and tell you all the other documents that have the exact same words. They're just, they aren't duplicates at that point usually. They're just what we call text duplicates, or you can do near duplicates, meaning that, 80% of the words are the same or 90% of the words are the same. Right. Thank you. That was great answers to a question that I think haunts a lot of people, both on the service provider side as well as the client side. So thanks. We went over a little bit on that slide, but I think that was valuable. Okay, slide on digital forensics questions. Start our timer. Number 1, what's the advantage of imaging a hard drive and live?
Sorry.
It's okay.
I just got confused there for a second between the collection and the digital forensics. Go ahead, Mark.
All right. Question number 1, what's the advantage of imaging a hard drive if imaging and live data collection are both forensically sound? 2, how can I search 3 terabytes of server data without collecting and processing it? 3, does Zoom have embedded video transcript like Microsoft Teams does? How is that data collected? What about Google Hangouts? 4, can mobile devices be collected remotely? Are we missing anything if we go that route? Number 5, are there additional measures to take when departing employee has been working remotely? So some similar themes, but to answer from a different perspective. Again, Adam, this is your world, but I'm sure that Brian's probably going to have some insight as well.
All right, so we're waiting on number 4. Ooh, boy.
Oof. Our audience is in sync. All right, number 4, mobile device questions. This is, we see a lot of these. BIA was formed as a forensics company, and we have digital DNA, we like to say. So, we do a lot of computer forensics work as well as our eDiscovery stuff. So, Adam, floor is yours again.
Yeah. Okay, thank you. So again, just as I said on the previous slide, every engagement, every collection effort, we start off with data mapping, not only speaking to the individual custodian, but also potentially speaking to their IT department to see if the device is under any kind of mobile device management or MDM. It is possible that is the case. If a device is managed under MDM, that poses challenges for doing collecting the device, being able to export data out of the device without specific permissions or authorization from that MDM system. That said, there is a possibility to remotely collect from iOS devices, that's iPhones and iPads, but at the moment, again, from the phone directly, Android devices are much more difficult to collect remotely. iPhone collections typically require full device backups due to security measures that Apple has put in place both in the software and hardware of the devices to protect consumer data. However, once preserved specific data such as text messages with specific individuals can be exported from the backups using forensic tools. Android devices, again, as I mentioned, they're more hands-on just, again, because of the architecture. They require a lot more hands-on with the device to put it in special modes, apply specific settings to them. And the Android ecosystem, there's just hundreds of different kinds of phones there that all work a little bit differently, different features installed by the software, the hardware vendor specific to their devices. That makes it pretty difficult to do this stuff easily. But that said, Android devices, specific information can be extracted from those devices as opposed to a full I'll just use the word backup or capture of an iOS device. iOS devices, we have to capture the whole phone to get at text messages, whereas Android devices, when we can collect from them, we can target just text messages. So again, mileage will vary depending on the type of device and specific operating system version and any secret sauce that the hardware vendor puts in software-wise on that device.
So, Adam, this kind of goes back to a proper scoping call at the beginning, right? Because you may not care about certain data points on the phone, but then you might also discover that, yeah, the person that owns this phone does have the Words with Friends game and potentially is using the chat feature inside that app to communicate with somebody about some insider trading. So, we keep drilling into the point of, ask the right questions at the beginning to facilitate a proper data preservation and collection and, move into, the review of that data. And cell phones are something that are not going to go away, or mobile devices, call them what you will. I showed my age there, sorry. But, you have to ask the right questions, really, I think, is part of your answer, right?
It's always about asking the right question and listening to the answer, because that answer could generate a few more questions for you to better understand what's going on and if the answer is past that initial question that's being asked.
So we had 100% on question 4. But, I think question 2 is also an interesting one because, we see lots of corporate clients of ours that have very large data sets, structured and unstructured. So, the question number 2 is, how can I search 3 terabytes of server data? I probably have to define what search really means without collecting and processing it, right? So
yeah, I would agree. I would agree with that. So, typically, in order to search any kind of data, you have to be able to index it first. That's true of Windows search or Spotlight on your computer, or if you're trying to run a search against your organization, or even run a search in SharePoint, right? Indexing has to be turned on somewhere in order to be able to run those searches. Otherwise, it's a very, very slow process, because then where you're searching from has to look at every document to see if it can find what it's looking for. That said, for large data sets, again, I keep on going back to data mapping. You can do a data assessment or triage on that data set. That assessment can often provide detailed knowledge about the type of data that are contained within the 3 terabytes on the server. Often we find that when dealing with large amounts of data on servers, not all the data is commonly processed. There could be a large amount of backup files, system files, program-related files, or multimedia files that just may not be relevant or potentially responsive to your case. So that assessment could be, running file listings or file type listings on it, just to understand what's there, understand the scope of what's there, so that, again, you can start making an assessment of what might or might not be important. Looking at file listings shouldn't be your end-all be-all necessarily. But it could be, depending on structure of data in that server share. So again, once the assessment is complete, it can provide you with additional information that you and/or counsel can make to make an informed decision on what to possibly collect or what's not to collect on the server. All of that information is just metrics, right, to let you know how big your problem may be. And what the cost might be of processing either the whole thing or being more targeted. That said, you should always speak to the custodians too. The data generally doesn't end up there without any user interaction through the use of custodian questionnaires. You can find out who's storing what where, how good, I use the term data hygiene or data structure. They store their files are, or groups of people store their data, so that you can really drill into what you can capture or preserve.
Thanks, Adam. And it looks like I might have made a presenter faux pas by not acknowledging there was question 5, which the results tabulated. But sorry, people who voted for question 5. We'll get that to you in our blog.
Well, Mark, actually, real quick, if for those people who are interested in that, if you just Google BIA exiting employee, you'll find the exiting employee checklist that we just published that covers that topic, along with literally, step-by-step questions and steps you should take for an exiting employee, especially in the remote world. So BIA exiting employee in Google, and you'll get the full answer along with the checklist right there.
Brian, I knew there was a reason we had you on the call today. That's wow-worthy right there.
Even a broken clock.
Just remember the exiting employee problem has gotten bigger because the remote employee issue has gotten bigger because these days just about everybody is a remote employee.
Yeah,
that's right. That's right. All right, let's head to our next slide. And so this one is data analytics and review hosting questions. So question number 1, what are some of the biggest mistakes you see people making with analytics tools? 2, there are so many analytics tools out there. How are they different, and how do I go about choosing? Does BIA have any favorites? 3, opposing counsel continues to send us productions as PDFs, and it's driving me crazy and costing a fortune to convert to TIFF and OCR. It's also costing us time. I'm concerned that we are missing metadata. Any guidance would be appreciated. 4, when and why do I need a clawback agreement? Are they used more often these days? And 5, am I ethically obligated to disclose that I used TAR to review and produce ESI? These are a bunch of great questions. I'm going to set the timer, and let's see if we have any results.
I think we have to push the poll.
That's right. Looks like we're going to be starting with question number 3.
That was.
Oh, wait a minute. She spoke too soon. We'll still start with question 3, and then we'll do 1 and 2. So, Lisa, our data diva.
3 was our OCR, yeah, our PDFs.
Yes.
So yeah, so you've got an opposing counsel who keeps producing in PDF. Really, there's 2 ways to look at it. If you've got an opposing counsel who's, frankly, not very sophisticated, and that is the reason they're producing in PDF, then, maybe it's something that you just kind of work with them with. But if you've got an opposing counsel who's doing it on purpose, and we definitely have seen those, then it's time to go a little further. The federal rules say that you need to produce your data, in a usable format. So it's pretty accepted that you should be producing metadata, searchable text, etc. Going back to that unsophisticated, opposing counsel, sometimes they'll think they are producing text as long as they're producing searchable PDFs. Unfortunately, most review platforms really won't do anything with searchable PDFs. You can go ahead and load a searchable PDF, but it's still going to just be the PDF. You'll need to OCR it. So, to the extent that you think they're doing it on purpose, then there are definitely rules, both federally and most states have similar rules saying that they can't, withhold the metadata and the text. If they're not doing it on purpose, they just don't quite know, then, maybe it's a little easier to work with them. And, maybe the answer is simply, getting them to agree that they'll, help get that metadata for you. Because some of the metadata is definitely important, and you would be right to be concerned that you're missing metadata if you're just getting the PDFs and not the metadata. The metadata can tell an awful lot of that story.
Yeah. And Barry, you've got some experience with this specifically. Is there anything you want to add?
Oh, we can't hear you, Barry.
No.
Took a hard pass.
Well, sorry about that. I had muted so you wouldn't hear me coughing. One of the things that we talk about with our clients is early on in a matter, get an ESI production protocol in place. And the production protocol will address the issues Lisa was just talking about, including which metadata fields are produced, what the format of the production is to be in, and it almost never calls for a PDF production unless that was the native version of the file. But also TIFF imaging is the way to go. Excel documents typically are produced natively. So spelling all of those issues out, those concerns out in the ESI protocol goes a long way to assuring both sides are receiving the information that they're entitled to receive. And the best time to get a production protocol in place is at the early meet and confers related to the matter. And those, in fact, that is about the only place in the federal rules where they talk about these types of things, is get them involved early on with the meet and confers.
Hey, Barry, just to add on to that. Well, first off, one quick thing. This has come up on a couple of times where we've dealt with individuals producing PDFs and even non-searchable PDFs, and have warned them, saying, look, you got to do at least TIFFs with OCR and metadata. That's industry standard, like you said, natives pretty much for Excels and sometimes PowerPoints and other types of files, audio, visual. The production standard in the industry is pretty pretty standardized these days. I mean, it used to be the day that we would be called on by clients to fight that all the time. Every single time somebody has produced that, an unusable or unsearchable PDF or just the PDFs without metadata, and we've gone to bat on that subject, we've won every single time. So, there's no question that it's not that if you've got somebody who's producing stuff that way, they're gonna, you can basically tell them, look, you can either be cooperative about it. If you don't know what you're doing, glad to help or have our vendor help you do it. But if we have to go back to the court and force you to do it, you're going to lose and you're going to get dinged for it as well and maybe even sanctioned. One quick thing, there was a question, is printing ESI in paper ever acceptable for production? If so, can you give an example of that? I figured might as well answer that now because it goes right along with this. And the answer is not really. Technically, printing the TIFF is kind of the same thing as printing to paper, but nobody really produces paper anymore. I mean, you still see it in really small cases. So that's one thing. Like I've always said, Barry talked about agreeing with your opposing counsel on a production format. If opposing counsel agree to produce all their documents, chiseled out on stone tablet, if they both agree to it, they agree to it. So you can always agree to anything you want to. But in general, producing to paper, producing boxes of paper, not only is it wasteful and extraordinarily more expensive, but it's rarely ever done and wouldn't really be appropriate unless for some reason, again, a small little case, a small arbitration, something parties agreed to produce, a handful of documents that way. Other than that, I would say that it would never be appropriate.
Great answers, guys. Thank you very much. Question number 1. What are some of the biggest mistakes you see people making with analytics tools? And we've got about 5 minutes.
Got it. I would start with not having the right people running it, simply because just because you have the tool does not mean that you can just throw everything at it and it will work beautifully. And that kind of goes into also prepping the data properly, segregating the data properly especially if we're talking about like a TAR process. TAR works, based on the text of the documents. So, to the extent that you've got documents where they don't have any text or they have very small amount of text, emails where you've got, just one line, or emails that literally just say "see attached." When you run that through a TAR process, you're really saying if let's say you code that document or you tag that document as responsive, you're telling the TAR engine, find every document that basically just says "see attached" and make it responsive, which is probably not what you're expecting to do. So just being able to segregate out the data properly, and really anyone not coding, we for a long time we said, you need to code on the 4 corners of the document, but even that makes it, that's a little harder to understand, because really what we need you to do is just look at the text. Anything outside of the text that about that document, the analytics engine doesn't know. So a lot of it is really understanding how the analytics works and working with it and not, kind of working against it. And to that end, thinking that the analytics tool is going to do the review for you. You can throw 500,000 documents in the analytics tool, and its job is to help you identify documents and help you segregate documents. Its job is not to do it for you. And to, it still requires some work on both the vendor end and on the attorney review end. And that's probably the biggest mistakes, is just, thinking that it's going to do it for you and not knowing how to use it properly.
Hey, Lisa.
Yep, go ahead.
Sorry, just really quick, while you're doing this, there's a question that came in. If a client gives you a list of search terms, do you rely just on that, or do you still conduct your own search terms? Just in terms of what you're talking about, I think that would be a great time when you're done to address that one too as part of it.
Yeah. I mean, so yeah, a lot of people will ask, and I know we have a question, I think it might be on the next slide, but basically, is keyword searching dead, or should we still use keyword searching? Keyword searching is not dead yet. I don't think it will ever be dead. Search terms are really good for finding something that is there. So, for example, if I want to know where my nearest Starbucks is, I'm going to Google Starbucks. And, that is a keyword, and that's what I'm looking for. But if I wanted to know, all the coffee places around, searching just for the word Starbucks is only going to find me Starbucks. It's not going to find me the other coffee places. So, to the extent that you've got a tool where you type in Starbucks and it says, okay, it seems like you're looking for, coffee places. Do you want to look for other coffee places? That's moving more into the conceptual, searching. So, whenever you've got keywords that will help you get to a place, help you get to documents you're looking for, it's great to start out with those. They're probably just not going to be the best way to approach the entire document review overall. It's just one piece that you use. One important piece of that would be, looking for privileged documents. Privileged documents really, in my opinion, do not do well in a TAR process, mainly because TAR is based on, the concept of the documents. It's looking for similar documents, not necessarily similar words, but, similar concepts. And privilege is more structural than that. If you've got if you've got an email from an attorney that says, gives an instruction to an employee, that document itself may be privileged solely because it's coming from that attorney. If you've got the exact same, sentence, but it comes from, just another employee, in the company, it's not going to be privileged. And a TAR engine is going to look at both those emails and think they're basically the same email, even though one would be privileged and one would not. So, using keywords to help identify certain documents, especially if you know exactly the documents you're looking for, or to help you identify, privileged names and stuff, keywords will always be important for stuff like that.
And I heard a timer go off there, but real quick, the one thing I also wanted to mention on this was like you were saying with the analytics tools, a big part of that is using expertise, right?
Right.
And isn't there something similar with search terms? Like, don't we see
Oh, absolutely.
And that was kind of one of the things I wanted to just quickly touch on is, search terms expertise comes into play there really importantly too. Can you 30 seconds on that before Mark moves us on to the next topic?
One of the big things that we notice is that people will try and use search terms, by going from the request for production and stuff and coming up with terms without really diving into the documents and finding out how people are actually talking. Knowing how people talk in a company, it will get you much further than just looking at the RFPs and looking to see what you're supposed to be producing.
And that bringing in the expert to really help you do that will make your search that much better.
Absolutely.
It's like anything else. Somebody who spends all their time doing this kind of stuff is just going to naturally know how to make them more effective. And
Right.
A little bit of money spent there will save you 10, 20, 100 times the cost later on for really making those terms, if you're using search terms, really making them effective. It's that thing where a little bit of time and effort spent on really bringing in somebody who specializes in that can make all the difference in the world and the rest of the process, right?
Absolutely. Yeah. I think it's really important to really nail those keywords down but know that they're not, that's not the end of the process. Once you've gotten a really good set of keywords, then you can kind of go into, your other analytic tools to help you find the documents that you're not going to find with the keywords.
Awesome. Thank you.
As we move to the next slide, and we're going to have about 7 minutes to focus on this slide, Lisa, just answer question number 5, if you would. Am I ethically obligated to disclose that I use TAR? It can be a short and sweet answer while I get ready for reading the next set of questions.
Am I ethically not? It depends on what your ESI order says. So if you've got an ESI order that says, both sides have agreed they're going to use TAR and they're going to disclose, what TAR engine they're using and what their recall and precision. If you've got an ESI order that says all of that, then yes, you are absolutely ethically obligated to disclose it because you signed it. But to the extent that you have an ESI order that says you are going to produce documents that are responsive to the request for production, then that is all you are obligated to disclose, is that you have reviewed documents and produced them. Attorneys have to state, they have to sign and they have to swear that the documents they've produced, meet the criteria that has been requested, and that it's not a document dump and you're not purposely withholding documents. How you get there, it really doesn't matter. And 20 years ago, nobody asked, did you have document reviewers open and read every single one of these emails, and did you have a document reviewer go through every single file folder? And it was just accepted that if you produced it, you were okay with what was in the document, and you were giving it to the other side because it met that requirement. Nothing has really changed in that. Again, to the extent that it's not specified in the ESI protocol, there really is no ethical obligation to say that you're using any type of analytics to help you get to the production.
Thanks. We get that question a lot, so thanks for giving a detailed answer. Okay, our final slide. We've got about 5 minutes left till the top of the hour. We certainly want to end on time, so managed review questions. And this could be a whole webinar by itself, but again, we'll answer any questions we don't get to in our BIA blog. Question number 1, is keyword searching dead yet? I think we've covered that a little bit, actually in detail. Number 2, I keep hearing conflicting information whether flat rate doc pricing is better than hourly, which is more cost effective, and why? 3, I don't have any experience managing doc review. We have a case where there'll be about 500,000 documents. My outside counsel has limited resources, but has a vendor they've used before. Any suggestions? 4, should we be using email threading? 5, will AI eventually eliminate the need for humans in doc review? And so people like question number 1. I think it's deserving maybe of a further discussion. And, how about we start with that, Lisa, and then maybe question number 4, which I think will be an easy one. Should we use email threading?
Sure. Go back to my questions. Number 1 was...
Is keyword searching dead yet?
Yeah, and just like we said, I don't think it's dead yet. I don't think it will ever be dead. There's really no replacing keyword. In particular, when you open up any of the analytics tools, most of them have places to use keyword searching. So, keyword still gets used. One place that I didn't mention earlier that we use keyword still is what we call anti-proximity searches. So, let's say you're looking for the word privileged, but you don't want it to hit in the footers of all the, every single email now has a footer that says privileged and confidential or some combination of those words. We can use what we call anti-proximity searches. So find me the word privileged not within, 0 words or 1 word of privileged and confidential in the footer. And, it's stuff like that where we still use keyword. It's also, even in the very beginning of a case, it's a very quick and easy way to get some idea of how many documents are even talking about, the topic that you're looking at. So I don't think it will ever be dead. It requires, I would just say it requires more, training than just knowing how to, type a word into Google. It's a little bit more complex than that if you want to use it appropriately and correctly.
It's an art form for sure. And Lisa, we've got 2 more minutes.
And then you said, which one you said 4?
We've got some new poll results in. So question number 5 is, will AI eventually eliminate the need for human review? I'll give you a minute for that one. And then question number 2 is a pricing flat rate versus hourly doc review question.
So will AI eliminate the need for document review? To some extent it already has. It may not eliminate 100% of the human review, but it's certainly reduced it significantly. We're able to tackle reviews of, 1 million plus documents, and not pages, documents, in less than 3 weeks with a team of 6 expert, analytical reviewers. In the past, that's something that, easily would have taken you 40 or 50 reviewers for a couple months. Beyond that, you'll always need humans who understand how to use the tools and, can accurately, divide the data up and choose which tools to use. So will it eliminate the need for humans in document review? I'm going to say a lot of it, yeah, but not 100%, but some of it, absolutely. And then number 2,
are you saying that
add a point there? Go ahead, Ryan.
I just want to make a point. You're saying less people, but I think this is one of those things where you could say it's going to become more of a question of quality versus quantity, right? It's no more. You can't just have a bunch of people and throw them at a project. if you're going to grab those fewer people have to have higher level of skills, better analytics understanding, all of that stuff. So it's a higher quality of training and experience, but a much lower quality or quantity, of people. Just
not quality, yes, quantity. Yeah, you need a handful of experts and not a big team of non-experts, basically.
And Lisa, let me add one point here on reviewers. And with privilege review, typically we see that we do need to have eyes on many of the documents.
Mark.
Well, we are at the top of the hour, so I want to be respectful of everybody's time, and we're really thankful that people joined today. All things considered, with webinar, fatigue and virtual meeting fatigue, it really means a lot for us to have people show up and engage. And hopefully, this was an enjoyable walk down eDiscovery lane with our experts this beautiful Tuesday afternoon. Like I said, we will answer the rest of our questions on our blog. And happy holidays to everybody. And we look forward to hearing from you and talking with you more next year. And thanks to everybody at ACEDS. As you know, we appreciate you guys and look forward to talking again soon. Have a great day, everybody. Thanks for joining.
Okay, thanks so much, Mark, and thanks everyone at BIA. Thank you for a great presentation today and the expert answers. Please visit aceds.org for a complete list of our upcoming webinars. Have a great day, everyone, and be kind to one another.
Thank you.
Thank you, Michael.